Good afternoon and welcome to all of you. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to introduce our annual George and Margaret Barrock Lecture on Criminal Law. I want to begin by saying a few words about the individuals whom by this lecture we remember. George Barrock was a Marquette lawyer, born in 1907, the child of immigrants from the area now known as Lebanon, and graduating in our class of 1931. His practice in Milwaukee emphasized family law, although he was fortunate in his own marriage. His wife, Margaret, was not only his partner for life, but also worked with him at the firm on administrative matters. A bequest to support an occasional distinguished lecture in George and Margaret Barrock's memory was provided by their daughter, the late Mary Bonfield. This is that lecture, which focuses annually on criminal law. This may not have been George Barrock's own specialty, but it is of a piece with his practice in that the criminal law involves individual citizens with everyday legal problems. Moreover, criminal law is an historic strength of Marquette University Law School. For scores of years, insofar as our teaching and our graduates' practices have been concerned, and in recent decades in terms of our faculty's scholarly attention. So we are really quite pleased to be able to offer this annual lecture series and grateful to all of you for being here with us. This year, we are most fortunate to welcome Gabriel J as our Barrock lecturer. He holds the Edward L. Barrett Chair of Law and serves as the Martin Luther King Jr. Professor of Law at the University of California, Davis. His teaching encompasses immigration law, criminal procedure, and race and law, among other fields. Professor Chin is widely published in these fields, with his work appearing in the law reviews at Duke, George Washington, Illinois, Penn, William and Mary, and Yale, among many other publications. He is an engaged citizen more generally, helping lead efforts in a number of states to repeal Jim Crow-era laws still on the books, and, for perhaps my favorite fact ever in introducing someone, he led the effort to persuade the state of Ohio, after some 136 years, finally to ratify the 14th Amendment. He holds degrees from Wesleyan, Michigan, and Yale, and today he will take up, for his Barrock lecture, Criminal Justice's Collateral Consequences. Won't you please welcome to Milwaukee and Marquette Law School, Professor Jack Chin.
Thank you, Dean, for that introduction. It's a particular pleasure to be here at a lecture that honors such a distinguished lawyer. I want to propose to you that the most significant thing the criminal justice system does, the most important thing, is not send people to prison, but instead to impose collateral consequences on people in free society. I'm not minimizing prison, but most people convicted even of felonies are not sentenced to prison. About 60% of people convicted of felonies receive straight probation or probation plus local jail time. Of course, even more defendants convicted of misdemeanors avoid incarceration. There are approximately 2 million people in prison today. 7 million people were on probation or parole at some point during 2015, but there are 75 million adult Americans with a criminal record of some kind. Some of those involve arrests not leading to conviction. But the vast majority of those, even who are convicted of felonies and sentenced to prison, will spend most of their lives in free society. I've prosecuted and defended criminal cases, and even since entering the academy, I keep my hand in. If we consider a serious felony that I've had some experience with, criminal sale of a controlled substance in the third degree in New York. Imagine a young adult going down the wrong path, sells a $10 crack rock to an undercover police officer and is arrested. Criminal sale of a controlled substance in the third degree in New York is a Class B felony, punishable by up to 25 years in prison. But, be realistic, it's just a $10 crack rock. It's very common for such a person, first offender, to receive straight probation, plead guilty to that offense, and walk out of court that very day, no jail, no prison. It seems like no big deal, but in fact, that individual has just been hit by a ton of bricks. People with convictions who are not incarcerated still feel the weight of the law. U.S. Supreme Court Justice Tom Clark described a felony conviction as something that strips an offender of all civil rights and leaves a shattered character that only a presidential pardon can mend. In other opinions, the Supreme Court elaborated on the nature of the shattered character. They explained that a felon customarily suffers the loss of substantial rights. This change is permanent because the disabilities carry through life. A convicted criminal may be disenfranchised, lose the right to hold federal or state office, be barred from entering certain professions, be subject to impeachment when testifying as a witness, be disqualified from serving as a juror. For purposes of our discussions, I want to define collateral consequences as the things that happen to a person automatically by operation of law as the result of a criminal judgment, forfeitures, and disabilities other than the sentence, other than prison, jail, probation, parole, fines. Collateral consequences were not particularly important in Blackstone's England or in early colonial America because the punishment for felonies was death. And if you're going to be executed, your inability to get a cosmetology license at some point in the future is not your biggest problem. But from fairly early on in the United States, we did not impose the penalty of death upon conviction for every crime. Collateral consequences almost entirely missed the criminal justice reforms of the 50s through the 70s. The criminal justice system was much smaller then, of course, and it may have appeared that there were bigger fish to fry. One of the things that was going on then is that rehabilitation was the predominant criminal justice ideal of that period. And in that period, it looked like collateral consequences were going away. Legislatures were repealing them. Scholars said that there was no justification for them and they should be eliminated. And it looked like a feature of the criminal justice system that was going to end. The view from 2017 is very different. There are so many areas of life now that are regulated by the government, and many of those areas are regulated through collateral consequences. So today, criminal conviction can make someone ineligible for public employment, such as in law enforcement or the military. It can preclude private employment, such as employment that requires a security clearance, employment for a government contractor or in a regulated industry, or in a field that requires a government license or permit. There's a classic story, which seems to be true, that there are prisons where the primary vocational training is barber training. Teach people how to cut hair, and those prisons are in states where barbers can't have a criminal conviction in order to get a license. Criminal conviction potentially affects many areas of family relations. The ability to adopt, to be a foster parent, to retain custody of children after a divorce. Conviction can disable a person from holding a government contract, from obtaining government licenses and permits. Conviction can make it impossible for a person to live in public housing or receive other public benefits, to collect a vested public pension. Those convicted of crimes can lose the right to drive a car. Of course, it's reasonably well known that people convicted of sex offenses have to register and can be excluded from living in particular areas and may even be subject to post-incarceration civil commitment. In any given jurisdiction, collateral consequences are normally triggered by a conviction from that jurisdiction or from any other. So a person with a conviction who moves from one place to another may be surprised to learn that they're subject to a whole new set of legal restrictions in their new place. There's an irony about collateral consequences, and that is the less serious the crime, the more significant the collateral consequences are as a portion of the punishment. Again, if someone is going to prison for 30 years for a string of armed robberies, the collateral consequences that might apply to them when they get out, no matter how serious, are not likely to be the most weighty parts of that sentence. But if someone pleads guilty to a misdemeanor and walks out of court that day, the fact that they're going to get deported, the fact that they won't be able to live in public housing, the fact that they might be prohibited from coaching their child's sports team, the fact that they might not be able to enlist in the military, those are serious problems. I want to talk about 4 characteristics of collateral consequences that I believe are problematic. The first is that at least for some people, collateral consequences are the most significant result of the criminal conviction, and yet, for the most part, they are not considered punishment for purposes of constitutional law. The Supreme Court has specifically held that occupational ineligibility, deportation, sex offender registration, and civil commitment are not subject to the prohibitions on ex post facto laws. The Supreme Court has also said that people with convictions may be prohibited from possessing a firearm or disenfranchised. They can lose their right to vote. The reason for this, says the Supreme Court, is that collateral consequences are civil regulatory measures. They're not criminal punishment, and therefore new collateral consequences are regularly imposed on people with old criminal convictions that did not originally carry those consequences. Many courts have held that because collateral consequences are not punishment, they're not subject to the Eighth Amendment prohibition on cruel and unusual punishment or the Fifth Amendment prohibition against double jeopardy. Like all governmental actions, imposition of collateral consequences might be unconstitutional if they're wholly irrational. But collateral consequences are subject, because they are civil regulatory measures, only to lenient rational basis review. As examples of the general lack of success of equal protection challenges, the 11th Circuit upheld the exclusion of people with convictions from a program designed to help people weatherize their homes. That program could permissibly exclude people with felony convictions or sex offense convictions because excluding those people saved money, and conservation of funds was a rational reason for exclusion. The District of Columbia Circuit and the 7th Circuit have upheld exclusion of people with convictions from employment in regulated industries and from public office as a reputational measure. Excluding people with convictions from particular organizations promotes public confidence in those institutions, and therefore it's rational to exclude people with convictions. Now, if saving money and promoting organizational reputation are sufficient reasons for exclusion from a benefit or forfeiture of a right, it's difficult to imagine any sort of exclusion or denial from almost anything which would be irrational. Because they're not punishment, generally clients are not entitled by the Due Process Clause to know what collateral consequences will apply before deciding whether to plead guilty or go to trial. So a trial judge accepting a plea, a defense attorney advising a client, doesn't have to advise that individual, at least as a matter of federal constitutional law, of the collateral consequences that are going to apply as a result of that conviction. The one exception is the collateral consequence of deportation. In Padilla versus Kentucky in 2010, the U.S. Supreme Court held that defense counsel had an obligation under the Sixth Amendment to advise a client that a guilty plea might lead to deportation. In my view, the logic of Padilla versus Kentucky goes further than that, but the cases don't necessarily agree with me. For example, in 2016, in a case called State versus Lemaire, the Wisconsin Supreme Court, 5-2, declined to extend Padilla versus Kentucky to post-prison sex offender civil commitment. Defense counsel has no obligation to advise a client that they might be subject to civil commitment as a result of the plea. And that seems like a pretty important effect of the decision, but the Wisconsin Supreme Court didn't agree with that. So the bottom line is that in spite of the prevalence of collateral consequences, or perhaps because of the prevalence of collateral consequences, federal constitutional law regulates them minimally. By and large, they're not subject to the criminal restraints of the Constitution. The second feature of collateral consequences that I think is important is that they're invisible. Collateral consequences are created by every type of law. They're created in the US Code, in the Code of Federal Regulations, in state codes, and in state regulations. They're also created by municipal ordinances. Collateral consequences can be created by agency policies below the level of regulations. These kinds of policies, of course, are not easy to discover. Collateral consequences can be triggered by offenses that are graded as felonies, misdemeanors, or as subcriminal violations or infractions, which exist in the codes of many states. There is, in effect, there is functionally a title of the code of every state called Regulation of Persons with Criminal Convictions. But that title has been scattered and spread out among all different kinds of law in that state, and it's very difficult to reconstruct. It's very difficult in any given jurisdiction to figure out the full scope of the legal consequences of a criminal conviction. One of the reasons, historically, that courts have said that trial judges and defense attorneys don't have an obligation to advise their clients of what's going to happen in this arena after a criminal conviction is that nobody can tell. Nobody knows. It's very difficult to find out, very costly to find out. And in a system of written law such as ours, that seems to me to be a significant indictment and embarrassment. There is a government-funded project now run by the Council of State Governments called the National Inventory of Collateral Consequences of Conviction. They're collecting the collateral consequences, at least in the state codes and the state administrative regulations of the 50 states. And it looks like there's going to be 40 or 50,000 collateral consequences on the books in the various American jurisdictions, mostly occupational disqualifications. But the collection is incomplete. Here in Wisconsin, the situation is a little better. Your recently retired state public defender, Michael Tobin, compiled or had compiled a number of useful guides which help explain the consequences imposed by Wisconsin law on criminal convictions. A group that I'm associated with, the Collateral Consequences Resource Center, also has a website with a database of Wisconsin consequences. The third thing about collateral consequences is that criminal records have become much more visible in recent years because of public and private databases. 30 years ago, it may have been that an old out-of-state marijuana conviction might not have had a significant impact on somebody's life because people wouldn't have been able to find it. Now, that's not the case. Here in Wisconsin, the Consolidated Court Automation Program makes criminal records easily available. Because of such databases, a criminal record is increasingly difficult to escape. At the same time, the legal effects of a criminal conviction are very hard to shake. all jurisdictions have some theoretical method of eliminating collateral consequences: pardon, sealing, expungement. But in practice, relief is often unavailable as a practical matter, or the relief is restricted to a narrow class of convictions or offenders. The fourth thing about collateral consequences is that they're often wrongly thought of as cost-free. The rationale seems to be that if we reserve public employment, if we reserve public benefits, if we reserve civil rights for law-abiding people, maybe we'll have better public services, we'll save money, we'll have a better society. But I propose to you that there is a cost to public safety, to the extent that people who could have led law-abiding lives instead recidivate. People who are unable to earn a living in the legitimate economy might well wind up making a living in some other way. There is a cost to society if people who could support themselves and their families and make a contribution to the community do not have the opportunity to do so. There's also, I believe, a cost in fairness and justice to the convicted people themselves. We have to consider whether redemption and forgiveness should be concepts entirely separated from the criminal justice system. There is a tradition that says that redemption should be possible. President George Bush, in his 2004 State of the Union address, said that America is the land of the second chance, and when the gates of the prison open, the path ahead should lead to a better life. Justice Janine Geske, who was a longtime faculty member here, as I'm sure you know, and now I believe is a university trustee, talked about ideas related to this in her writing about her restorative justice work. She talked about meetings between murderers, rapists, armed robbers, and drug dealers, and family members of homicide victims and sexual assault survivors to help the latter begin to heal and find peace, and the former appreciate the depth of the harm they have caused and work towards demonstrating their remorse and restoration of the victim in the community. I think her work, as she put it, truly holding offenders accountable, not just accountable because they spend years behind bars, but emotionally accountable for the harm they caused, implied that at some point the accounts can be settled and the debt can be paid. I am not a prison abolitionist. One hobby that I'm able to indulge, given the flexibility of my job as a law professor, is prosecuting sex offenders in my spare time, and I find it very satisfying work. But at least for people with convictions who want to reform, at least for people with convictions who are working to lead law-abiding lives, I think we have to ask ourselves if at some point society has to find a way to let them move on. In the last couple of decades, some important legal institutions have, one after another, taken a hard look at collateral consequences. The American Bar Association promulgated the Criminal Justice Standards on Collateral Sanctions and Discretionary Disqualification of Convicted Persons in 2003. The Uniform Law Commission issued the Uniform Collateral Consequences of Conviction Act in 2009. And just this year, the American Law Institute approved a new set of sentencing provisions for the Model Penal Code. I was involved in all of these projects, and these projects had a Wisconsin connection as well. Justice Ann Walsh Bradley was involved, as was Professor Cecilia Klingel, who teaches at what I understand is the second best law school in this state. And all of these reform efforts had shared 5 points. One is that defendants should receive notice of the collateral consequences that they're going to face before they decide whether to plead guilty or go to trial. They should have some sense of what's going to happen. The second thing is that judges should consider collateral consequences as part of the package of sanctions at sentencing. Third, that collateral consequences should be collected in each jurisdiction and made available so that the first two things can actually happen. The fourth is that there should be a possibility of waiver of individual collateral sanctions early on at the time of sentencing so that an individual has a better chance of making it. And then after a period of years of good behavior, that there should be an opportunity for a judicial or administrative pardon, which would symbolize and have the legal effect of restoring their status as an equal member of the community. And the fifth thing is that legislatures should limit collateral consequences to those that actually are worth it, and that they should do so in light of social science research, which shows that after periods of crime-free behavior, the risk of reoffending diminishes for particular individuals and ultimately returns to baseline, returns to that in the general population. At a certain point, a prior conviction of some age is not predictive of future misconduct, and that these judgments that are made about public safety and exclusion from particular parts of society should be based on empirical data, empirical information, not simply intuition alone. So, I do not have the honor and benefit of having been born in Wisconsin myself. But I understand that there is something called, a thing called Wisconsin nice. Is that true? I flatter myself to think that the argument that I have made falls into that category. I've tried to be reasonable, tried to be balanced, a little bit of economic efficiency, a little bit of public safety, a little bit of fairness to the individual. I want to introduce an argument, an idea that I'm working on that's not too nice. The argument has a feature that I call "Our Dumb Framers." And I hasten to add that that title has a question mark at the end of it. Our framers had a lot of qualities, but I don't believe that they were dumb. My half-baked argument that I want to at least introduce you today is that there's an irreconcilable inconsistency between the ex post facto cases, the cases interpreting the ex post facto prohibition of the Constitution of the founding era, and the ex post facto cases of the modern court. My proposition to you is that either the 20th century court or the founding era court has erred. And I am going to say that it was the modern court that blundered and therefore should rethink the constitutional treatment of collateral consequences. Here's one reason why I think it was the modern court that erred rather than the founding era court. Constitutional interpretation for the early Supreme Court justices was a much simpler proposition. When they wanted to know what a particular clause of the Constitution meant, they would just ask themselves, what did I mean when I drafted that? What was I thinking? Or they would say, just exactly what injustice perpetrated by the Redcoats made me join the Minutemen. I think they had some good insight into the problems that the Constitution was designed to address. The key Supreme Court case on the ex post facto clause is a decision called Calder versus Bull, written in 1798 by Justice Samuel Chase, who was a signer of the Declaration of Independence. Calder versus Bull is, I believe, still regarded as authoritative today. I believe that every justice of the court who has expressed an opinion in the last 50 years has suggested that Calder versus Bull is the source of law that controls. Calder versus Bull identified 4 categories of laws that violated the ex post facto clause. The first category was every law that makes an action done before the passing of the law and which was innocent when done, criminal, and punishes such action. It's clear enough. I'm going to take them out of order. Category 4th, every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. So, Chapter 946 of the Wisconsin Code criminalizes treason, sabotage, sedition, and misuse of the flag. Treason, according to the statute, has to be proved by 2 witnesses to the same overt act or by confession in open court. Now, Wisconsin could change the law and allow conviction by a single witness or based on an out-of-court confession, but it could only do that with respect to conduct that occurred after the amendment. The third category, every law that changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. Then the second category, and this is the one that I suggest to you is relevant for our purposes. Every law that aggravates a crime or makes it greater than it was when committed. What does that mean? Well, a couple of things are clear. First, the second category isn't about punishment. That's a third category. It must be about something else. Second, there's no special attention given in that definition to the legislative characterization of the thing, of the new restriction as civil or criminal. The founding era court and the modern court agree that the content of the ex post facto clause, the excesses of Parliament that led the framers to include the ex post facto clause in the Constitution, were set out in a treatise by Oxford law professor Richard Woodson, which has been cited approximately 24 times in the US Supreme Court between 1798 and the last time was 2013. And Woodson, in my reading, makes clear that the second category of ex post facto consists of what we would now call collateral consequences. What it meant to aggravate a crime or make it greater than it was, according to the Woodson treatise, was if it, quote, made some innovation or created some forfeiture or disability not incurred in the ordinary course of law. In Stogner versus California in 2003, all 9 justices, the Breyer majority opinion and the Kennedy dissent, all 9 justices agreed that that exact passage provided the substantive content of the meaning of the second category of ex post facto. They quoted the innovation, forfeiture, or disability language from Woodson. In the founding era, the terms forfeiture and disability had the meanings that they have today. In early cases like 200 chests of tea, argued by Daniel Webster and decided by Justice Story, and many, many other cases like that, forfeiture is an in rem taking of property based on misconduct of the person who owned or controlled the property. So it's forfeiture like civil asset forfeiture today. A disability is a loss of civil rights or status. So in Knott versus United States from 1877, which is a little after our period, but I think it's accurate, the court says, a pardon releases the offender from all disabilities imposed by the offense and restores to him all his civil rights. In contemplation of law, it so far blots out the offense that afterwards it cannot be imputed to him to prevent the assertion of his legal rights. And we also see early Supreme Court cases talking about disabilities of non-citizens. So at that time, a non-citizen might not be able to inherit real property from a citizen, and that was a disability. We talk about, the court talks about the disabilities of people born out of wedlock. They too might not be able to inherit from certain of their blood relatives based on particular circumstances. So disability is a situation where an individual, for some reason, has diminished legal and civil rights in the context. There's a treatise by William Wade, written in 1880, towards the end of the 19th century, and the Wade Treatise has regularly been cited by conservative members of the Supreme Court. And Professor Wade in 1880 surveyed the precedents and gave this summary of the ex post facto clause. Any statute which deprives an individual of a valuable privilege, such as that of the elective franchise or the right to pursue a lawful avocation, as a consequence of acts which were, at the time of their commission, not punishable at all, or not in that manner, on the ground that such a law retroactively imposes a penalty or forfeiture. So under those conditions, the law is ex post facto, it's void. The Supreme Court decisions that Wade looked at to reach that conclusion were from a pair of decisions, Ex parte Garland and Cummings versus Missouri, decided immediately after the Civil War. And the critical language in this respect from those opinions is this: and exclusion from any of the professions or any of the ordinary avocations of life for past conduct can be regarded in no other light than as punishment for such conduct, says Ex parte Garland. Cummings versus Missouri: the theory upon which our political institutions rest is that all men have certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, and that in the pursuit of happiness, all avocations, all honors, all positions are alike open to everyone, and that in the protection of these rights, all are equal before the law. Any deprivation or suspension of any of these rights for past conduct is punishment and can in no otherwise be defined. Punishment is not restricted, as contended by counsel, to the deprivation of life, liberty, or property, but also embraces deprivation or suspension of political or civil rights. Here's the our dumb framers part. The modern court says that even if we call them disabilities or forfeitures, deprivations of employment, public benefits, licenses, permits, civil rights, they're not ex post facto because Congress and the state legislatures that imposed them intended them to be civil sanctions, not criminal. The key, says the modern court, is the intent of the legislature. The intent of the legislature is, in this context, a tricky criterion, because the court has noted that the laws applicable to past conduct are most common in times of political controversy. So in Cummings versus Missouri, the court says, bills of this sort, says Mr. Justice Story, quoting Story's commentaries, have most usually passed in England in times of rebellion or gross subserviency to the crown, or of violent political excitements, periods in which all nations are most liable, as well the free as the enslaved, to forget their duties and to trample upon the rights and liberties of others. So we have a provision that's designed to restrain the legislature in times of political turmoil, says the modern court, but it applies if and only if the legislature chooses to be restrained. That's a difficult interpretation, in my view. More fundamentally, does anyone think that the framers were such poor lawyers that they meant to make the ex post facto prohibition so easy to get around? The ex post facto clause absolutely prohibits innovative penalties, disabilities, or forfeitures unless the legislature uses the magic word civil. Then it's fine. There's actually two ex post facto clauses in the Constitution. Article 1, one applies to the states, the other one applies to Congress, but they're both meaningless technicalities. I say the answer is no, that the framers were not that bad at legal drafting that they left this loophole in the instrument. And I'm bolstered in my conclusion by the fact that this issue came up in the founding era and later in the 19th century, and in decisions that I do not feel have been fully dealt with by the modern court, the court made clear that a functional approach to the ex post facto clause would apply. In 1810, Chief Justice John Marshall, one of your top chief justices, in my view, decided a case called Fletcher versus Peck. Fletcher versus Peck involved an insider land sale in Georgia, the Yazoo land fraud, where one Georgia legislature sold a bunch of land that was owned by the state to favored insiders at a very low price. And they're all kicked, democracy works, and they're all kicked out of office, and a new legislature comes in, and the new legislature passes a law that says that the land titles issued by the previous legislature are void. So these people took a corrupt, the fruits of a corrupt situation, and the new legislature takes it back. And the case ultimately gets to the US Supreme Court. Can the new Georgia legislature do that? Can they void the land titles? And this is what the court said. The state legislatures can pass no ex post facto law. An ex post facto law is one which renders an act punishable in a manner in which it was not punishable when it was committed. Such a law may inflict penalties on the person, or may inflict pecuniary penalties which swell the public treasury. The legislator is then prohibited from passing a law by which a man's estate, or any part of it, shall be seized for a crime which was not declared by some previous law to render him liable to that punishment. Why, then, should violence be done to the natural meaning of the words for the purpose of leaving to the legislature the power of seizing for public use the estate of an individual in the form of a law annulling the title by which he holds that estate? The court can perceive no sufficient grounds for making this distinction. The rescinding act would have the effect of an ex post facto law. It forfeits the estate of Fletcher for a crime not committed by himself, but by those from whom he purchased. This cannot be effected in the form of an ex post facto law or bill of attainder. Why, then, is it allowable in the form of a law annulling the original grant? And the court said, it isn't. Later cases, Cummings versus Missouri, the provision of the federal Constitution intended to secure the liberty of the citizen cannot be evaded by the form in which the power of the state is exerted. If this were not so, if that which cannot be accomplished by means looking directly to the end can be accomplished by indirect means, the inhibition may be evaded at pleasure. No kind of oppression can be named against which the framers of the Constitution intended to guard, which may not be affected. The William Wade Treatise looked at these things and came to the conclusion that what the decisions meant was, whether the end be attained directly or indirectly, it will be as obnoxious to this constitutional objection as though expressed in clear and positive terms. So the founding era court and 19th century scholars and judges recognized that the ex post facto clauses were substantial, meaningful restrictions which could not be nullified through magic words or clever lawyering. As I said, recent Supreme Court cases continue to recognize the authoritative nature of Calder versus Bull and the Woodson Treatise, and I hope the court will return to the question of why a specific thing that the framers of the Constitution intended to prohibit, innovative forfeitures and disabilities, is allowed by the modern cases. And I believe that just this year, the court has noticed the problem. Earlier this year, in a case called Packingham versus North Carolina, the Supreme Court unanimously invalidated a prohibition on sex offenders accessing the internet. It was mostly a First Amendment case, but the majority opinion by Justice Kennedy contained the following line. Of importance, the troubling fact that this law imposes severe restrictions on persons who already have served their sentence and are no longer subject to the supervision of the criminal justice system is also not an issue before the court. When I read that, I was completely surprised. That is an observation along the lines, has anyone noticed that Congress has authorized the circulation of greenbacks in addition to gold and silver as money? I thought that they already knew that. but evidently they're coming back around to it. And so my hope is, and I'll close with this observation. My hope is that cases like Padilla versus Kentucky and Packingham versus North Carolina will suggest that there's a reconsideration of the heretofore reasonably well-established conclusion that collateral consequences are beyond the Constitution, and therefore that the looming possibility of constitutional regulation will encourage legislatures, as a matter of policy, to make more strenuous efforts to fit them in a more sensible and rational way into the criminal justice system. So thank you, and with that, I think we'll take some questions.
Thank you. We will take some questions. So I see that your hand is already up. If you can press the rim of the ball. Terrific.
First, one comment and then a proposal thesis. When you were discussing Padilla versus Kentucky, you said that they let him out with that found ineffective assistance because he might be deported. When in fact what the court held was deportation was such an absolute certainty that it was ineffective assistance of counsel for him not to know that. And so for that reason, it's extremely difficult for any lower court to expend Padilla because it was explicitly limited to the absolute certainty.
Second, I was wondering what you think of this thesis, which is that the court knows very well that all the ex post facto problems that you're discussing. However, they are worried about that extending into, say, ineffective assistance, or defendants arguing, well, I didn't know the consequences. Even consider if someone gets a felony conviction, they could then go to Marquette Law School here, pass the bar exam, and the Supreme Court could still say, no, you can't practice law because it's felony way back then. And, you know, basically, I agree with you. The number of collateral consequences are so numerous that it's not possible, it's not realistic that a guilty plea to expound them all. And the reason the court's ex post facto jurisprudence is so wrong is simply that they're worried about a plethora of criminal convictions being overturned for really reasons that it had nothing to do with the defendant's, what he was thinking about when he pleaded guilty.
Well, of course, to establish an effective assistance of counsel, you have to show that it was, transaction causative, right? That you wouldn't have pleaded guilty or made the decision that you would have, but for the misadvice or the non-advice. I think the deportation in Padilla versus Kentucky was not automatic because there were methods under the ground of deportability that was talked about in the opinion that could be waived or let go.
There was no discretionary relief for the conviction that he had.
Well, we're going to have to agree to disagree on that. But let's say you're right. That is the normal characteristic of collateral consequences, that if you have a particular criminal conviction, then you are ineligible for this benefit, that license, this form of public housing. So it has that same automatic quality. So I see your point, but the other thing is that the finality of the guilty plea problem could be eliminated through application of ex post facto, right? You could say, well, you don't get your guilty plea back because this new thing doesn't apply to you with your 10-year-old guilty plea.
I'm just asking if you think that that's a fear that the court has.
Oh, sure, absolutely.
That door. What else do they open the door to?
Absolutely. But one of the things that Justice Stevens said in Padilla is that most of the collateral attacks on convictions, and as assume that you're in the business, and so, collateral, if you're going to raise an effective assistance at counsel, generally you have to do it through a collateral attack because you need non-record evidence to make the argument. Most collateral attacks are on trial cases. They're a tiny fraction of the collateral attacks, said Justice Stevens in the Padilla opinion, are against plea cases, because if you win, all you do is get your plea back. And then you face the full set of problems that made you decide to take the plea in the first place. And so the mere fact that you might be able to get your plea back for some reason doesn't mean that you want to get your plea back for some reason. And in a trial case, the calculation is often different.
So let's take other questions. Thanks. Other questions? Yes, if you can wait for the microphone, and that way we'll all be able to hear it. Thank you.
Thank you, Professor. Given that last discussion, what would be the category or class of collateral consequences that you think the High Court would entertain rather than a blanket attack on all?
Well, the ex post facto argument applies only to new collateral consequences imposed based on old convictions. And so that would be the extent of the argument that I've outlined here. It wouldn't be, it wouldn't substantively limit collateral consequences at all. I do think that there are other constitutional problems with collateral consequences. I think in other work, I've argued that the status that a person enjoys once they have a criminal conviction for a felony or a misdemeanor is sufficiently similar to the historical punishment of civil death. And civil death was the status that someone convicted of a felony enjoyed. The law wrapped up their legal existence as it prepared to impose capital punishment, so it would impose legal death upon conviction, civil death upon conviction, and then natural death when the sentence was carried out. But the status that people enjoy once they have a criminal conviction, where any rational collateral consequence can be imposed upon them at any point, that makes you sufficiently distinct from the free and equal person that the judges talked about, that you should, whether or not you are entitled to be warned of particular collateral consequences, you certainly are entitled to be warned that you're going to suffer the modern equivalent of civil death, which was recognized as a punishment historically. And so at a minimum, there should be a warning that if you plead guilty to a felony or to a misdemeanor, or in some cases to an infraction or violation, that for the entire rest of your life, anything that the legislature or the city council or any other government entity decides to do to you, they can do, unless it's irrational. And in some small number of cases, a sanction will be found to be so disproportionate that it will be irrational. But for the most part, those kinds of claims, as I've said, have been unsuccessful. So I think the Constitution requires a warning that your status is going to change from that of a free and equal individual to a highly regulated and regulable situation. But I don't have, working off of existing cases and working off of existing doctrine, I have some of these procedural ideas, but largely because we do not have a very robust Eighth Amendment proportionality of punishment jurisprudence, I don't have an argument that as a matter of constitutional law, that large categories of collateral consequences must be eliminated.
So keeping to our 5:30 time period, I think we have time for one more question. Yes, please. Can you press that button? Terrific. You're a pro.
Bearing in mind the natural consequence that maybe losing one's livelihood would have on one's family, could you comment maybe separately on the effect of collateral consequences, maybe in the area of public benefits and housing, not necessarily to the person who's been convicted to himself, but to his immediate family, having actually had to assist a client in this area who had a domestic abuse conviction in the past and was denied subsidized housing as a result of it by an agency? In other words, there's collateral consequences like families can lose housing as well.
Absolutely. And so the federal law now provides that if anyone in a public housing unit is convicted of a specified offense, then the lease has to be terminated, or the lease has to be terminable. And whether the public housing authority decides to actually evict is to some extent a separate question. But there are lots of third-party effects. An individual can lose a pension based on a criminal conviction, and that obviously will affect the defendant's family as well. I believe that, in the federal sentencing guidelines, with respect to, and in the Department of Justice principles of prosecution of organizational defendants, one of the criteria that is used about whether the U.S. Department of Justice will charge an organizational defendant with a crime is whether there will be collateral consequences to innocent third parties, shareholders, employees, contractors, innocent employees, et cetera. And federal prosecutors can and do look at an institution and say, they're guilty, and we could hammer them, but if we do, a lot of innocent third parties are going to suffer, so we won't. We'll do something else. That discretion is not written into the principles of prosecution for individuals in the Department of Justice or elsewhere, but I think it should be. I don't understand why a prosecutor can't look at a criminal case against an individual and say, maybe there's some other way to handle this that wouldn't, to protect public safety and hold the individual accountable for what they've done, but that wouldn't cause suffering, disruption, loss of benefits, housing, income, et cetera, for innocent third parties like that person's family, et cetera. So I see your point.
So let me do three things. One, I want to mention that we have a reception right outside in the Zilber Forum where one can continue to press questions on Professor Chin while maybe he eats a cookie. Second, I want to thank all of you for being here. This is a wonderful crowd. The Barrock Lecture on Criminal Law really has become one of our premier academic gatherings, and we are grateful to all of you for being here. Third, and the reason that it's become such a premier academic gathering is that we are able to attract people such as, in this instance, Professor Chin, whom I really want to thank very warmly on behalf of all of us for a terrific addition to our Barrock Lecture Series. Thank you so much.
Thank you.